Hello, my name is Karen O'Leary and I'm a family law practitioner in the firm Caldwell and Robinson in Northern Ireland. Today I'm going to speak on the directive of the 13th of December 2011 on the European Protection Order and proposal for a regulation on mutual recognition of protection measures in civil matters. I will firstly discuss the directive on the European Protection Order, which enables anyone protected under criminal law in one EU member state to apply for the same level of protection in other member states should they move or travel without going through expensive and time-consuming procedures. I will then move on to discuss the proposal for a regulation on mutual recognition of protection measures in civil matters. This proposal, dealing with protection measures taken in civil matters, aims at complementing the directive on the European Protection Order, and it currently goes for trilogue with the European Parliament. The combination of the two instruments should cover the broadest possible range of protection measures issued for victims of violence in EU member states. Turning to the directive on the European Protection Order. The purpose of the directive is to protect victims of violence. Protection measures may be issued by a judicial or other authority upon the request of the person at risk. Protection measures may consist of, for example, the obligation not to approach the protected person closer than a prescribed distance, or the obligation not to enter certain localities where the protected person resides or that he visits. A specificity of many protection measures is that the public authorities do not actively intervene to ensure their execution. In cases of violation of the obligation by the person causing the risk, that person is directly subject to a sanction, often a criminal sanction. Measures to protect victims of crime from aggressors already exist in EU member states, but up until this directive, they ceased to apply if the victim travelled or moved to another member state. Given the increased movement of people across EU borders, it has become increasingly relevant to ensure that temporary protection measures provided in one member state are maintained when a person travels or moves to another member state without having to go through time-consuming procedures. This directive recognises the legitimate exercise by citizens of the Union of their right to move and reside freely within the territories of the member states, in accordance with Article 3.2 of the Treaty on the European Union and Article 21 of the Treaty on the Functioning of the European Union, and ensures no loss of any protective measures secured in one member state whilst in another member state. In order to achieve these objectives, the directive allows for a competent authority in one member state, known as the issuing state, in which a protection measure has been adopted, to issue a European Protection Order enabling a competent authority in another member state, known as the executing state, to continue the protection of the person in the territory of the executing state, in accordance with the national law of the issuing state. The directive aims to avoid the need for the victim to start new proceedings or to produce evidence in the executing state again, as if the issuing state had not adopted the decision. The directive covers all victims of crime. It aims to apply protection measures specifically to protect victims or possible victims who need protection against a criminal act of another person which may in any way endanger his life, physical, psychological and sexual integrity, as well as his dignity or personal liberty. Such acts could include harassment, abduction, stalking, and other forms of indirect coercion. The directive will not therefore apply to measures adopted with a view to witness protection. This directive only applies to protection measures adopted in criminal matters, and therefore does not cover protection measures adopted in civil matters. For a protection measure to be executable in accordance with this directive, it is not necessary for a criminal offence to have been established by a final decision. The directive also takes account of the different legal traditions of the member states and does not oblige a member state to amend their national law to enable them to adopt protection measures in the context of criminal proceedings. The directive also recognises that effective protection can be provided by means of protection orders issued by an authority other than a criminal court. Once a person is granted protection in one member state under domestic criminal law, he or she may request a European protection order. And a European protection order means a decision taken by a member state in relation to a protection measure, on the basis of which another member state takes any appropriate measure under its own national law with a view to continuing the protection of the protected person. Therefore, a protected person may request a European protection order to extend this protection to another EU member state to which he or she decides to move or has already moved. A European protection order may be issued when the protected person decides to reside or already resides in another member state. When deciding upon the issuing of a European protection order, the issuing state shall take into account the length of the period that the protected person intends to stay in the executing state and the seriousness of the need for protection. In the procedures for the issuing and recognition of a European protection order, competent authorities should give appropriate consideration to the needs of victims, including particularly vulnerable people such as minors or people with disabilities. Article 5 of the directive provides that a European protection order may only be issued if the aggressor is banned by the issuing state from places where the protected person resides or which he or she visits, or if restrictions are imposed on contact or approaches by the aggressor to the protected person. These prohibitions and restrictions, which, when imposed in the issuing state and included in the European Protection Order, should be recognised and enforced by the executing state. The issuing state may issue a European Protection Order only at the request of the protected person and after verifying that the protection measure meets the requirements previously stated. A European Protection Order may also be requested to safeguard the relatives of a beneficiary of a European Protection Order. The protected person may submit a request for the issuing of a European Protection Order, either to the competent authority of the issuing state or the competent authority of the executing state. If such a request is submitted in the executing state, its competent authority shall transfer this request as soon as possible to the competent authority of the issuing state. In accordance with Article 6 of the European Convention for the Protection of Human Rights and Fundamental Freedoms, together with the second paragraph of Article 47 of the Charter of Fundamental Rights of the European Union, the person causing the danger should be provided either during the procedure leading to the adoption of a protection measure or before issuing a European Protection Order, with the possibility of being heard if they wish to challenge the protection measure. If the request to issue a European protection order is rejected, the issuing state shall inform the protected person of any applicable legal remedies that are available under its national law against such a decision. Upon receipt of a European protection order, the executing state shall, without undue delay, recognise that order and take a decision adopting any measure that would be available under its national law in similar case in order to ensure the protection of the protected person, unless it decides to invoke one of the grounds for non-recognition. The executing state may apply, in accordance with its national law, criminal, administrative or civil measures. The measures adopted by the executing state shall, so far as possible, correspond to the protection measure adopted in the issuing state. The executing state is not required in all cases to take the same protection measures as those which were adopted in the issuing state, and has a degree of discretion to adopt any measures which it deems adequate and appropriate under its national law in a similar case in order to provide continuing protection to the protected person in light of the protective measures adopted in the issuing state as described in the European Protection Order. The executing state shall inform the aggressor, the issuing state and the protected person of any measures adopted, as well as the possible legal consequences of a breach of such measure provided for under their national law. In the notification to the aggressor, due regard should be taken of the interest of the protected person in not having their contact details disclosed. If the executing state considers that the information contained with the European Protection Order is incomplete, it shall without delay inform the issuing state, assigning a reasonable period for it to provide the missing information. Article 10 of the Directive provides the various grounds for non-recognition of a European Protection Order, including, for example, the protection measure relates to an act that does not constitute a criminal offence under the law of the executing state, where the executing state refuses to recognise a European Protection Order. It shall, without undue delay, inform the issuing state and the protected person of this refusal and of the grounds relating thereto, and where appropriate, inform the protected person about the possibility of requesting the adoption of a protection measure in accordance with its national law, and inform the protected person of any applicable legal remedies available under its national law against such a decision. The executing state shall be competent to adopt and to enforce measures in that state following the recognition of a European Protection Order. In the event of a breach of a measure taken by the executing state following the recognition of a European Protection Order, the executing state shall be competent to impose criminal penalties, take any non-criminal decisions related to the breach, and take any urgent measure in order to put an end to the breach, pending, where appropriate, a subsequent decision by the issuing state. The executing state shall notify the issuing state in the standard form of notice of any breach of the measure taken on the basis of the European Protection Order. The issuing state shall have exclusive competence to take decisions relating to the renewal, review, modification, revocation and withdrawal of the protection measure and consequently of the European Protection Order. The issuing state shall inform the executing state without delay of any of the above decisions. If the issuing state has revoked or withdrawn the European Protection Order, the executing state shall discontinue the measures adopted on the basis of the European Protection Order as soon as it has been duly notified by the issuing state. The executing state may discontinue the measures taken in accordance with the execution of the European Protection Order, where there is clear indication that the protected person does not reside or stay in the territory of the executing state, or has definitely left that territory, and where, according to its national law, the maximum term of duration of the measures adopted in the execution of the European Protection Order has expired. The executing state shall immediately inform the issuing state and the protected person of such a decision. A European Protection Order shall be recognised with the same priority which would be available in a similar national case, taking into consideration any specific circumstances of the case, including the urgency of the matter, the date foreseen for the arrival of the protected person in the territory of the executing state, and, where possible, the degree of risk for the protected person. Where appropriate, the competent authorities of the issuing state and of the executing state may consult with each other in order to facilitate the smooth and efficient application of the directive. In terms of costs, the costs arising from the application of this directive shall be borne by the executing state in accordance with its national law, except for costs arising exclusively within the territory of the issuing state. Certain protection measures are already covered by Brussels 1 and Brussels 2A. Hence, when a decision relating to a protection measure falls within these Council regulations, the recognition and enforcement of that decision should be carried out in accordance with the provisions of the relevant legal instrument. Given that the objective of this directive is to protect people who are in danger, if this cannot be sufficiently achieved by the Member States, and can therefore, by reason of its scale and effects, be better achieved at Union level, the Union may adopt measures in accordance with the principle of subsidiarity as set out in Article 5 of the Treaty of the European Union. In accordance with the principle of proportionality as set out in that article, this directive does not go beyond what is necessary in order to achieve that objective. This directive on European protection orders was an initiative originally requested by 12 Member States and promoted by the EU Spanish presidency in the first half of 2010. The UK decided to participate in the European protection orders by using the opt-in option provided for in Protocol 21 of the Lisbon Treaty. But Ireland and Denmark have declined to take part in the adoption of this directive and are not bound by it or subject to its application. Member States will bring into force the laws, regulations and administrative provisions to comply with this directive by the 11th of January 2015. By the 11th of January 2016, the Commission will submit a report to the European Parliament and to the Council on the application of this directive. That report will be accompanied, if necessary, by legislative proposals. The UK joined a number of other Member States in objecting to a criminal legal base being used for both criminal and civil protection orders. As a consequence, this directive is restricted to criminal matters, and the Commission's proposed new regulation will complement this directive and deal only with civil protection orders. The combination of the two instruments should cover the broadest possible range of protection measures for victims issued in Member States. The Commission is proposing a regulation aimed at ensuring that civil law protection measures issued by a Member State will be easily recognised in the rest of the EU without any further formality other than a standardised and multilingual certificate. The scope of this proposal, whilst limited to civil matters, is wide enough to accommodate the different approaches of Member States to such orders. This is reflected in the recognition that an issuing authority will not necessarily be a court. Measures covered by Brussels 2A, which concerns conflicts of jurisdictions in matrimonial proceedings, are excluded from its scope. Due to their more specific nature, the measures provided for by this regulation will replace those on the jurisdiction, recognition and enforcement of judgments in civil and commercial matters. This proposal is a mutual recognition instrument in civil matters, and as such it follows the rationale of existing EU instruments on judicial cooperation in civil and commercial matters, from which it takes broad inspiration. No intermediate procedures are required, the recognition is automatic. There is an open list of measures that can be construed as protection measures, with emphasis placed on the fact that they are preventative and temporary in nature. Jurisdiction is to lie with the authorities of the Member State where the person's physical and/or psychological integrity or liberty is at risk, and this generally dovetails with the habitual residence of the person at risk. The standardised certificate is necessary for the person at risk to invoke the protection measure in another Member State. The certificate will be issued at the request of the protected person by the Member State of origin in the standard form. Then, it will be up to the party who wishes to invoke the protection measure in the Member State of recognition to provide that Member State with the issued certificate. The standardised certificate will be automatically recognised in another Member State with very limited grounds for refusal. However, a protection measure can be adapted in the state recognising the order to one that has equivalent effect and pursues similar aims. It appears that that might allow a civil order in one Member State to be treated as a criminal order in those Member States which do not have equivalent civil orders. The procedure for enforcement will be governed by the law of the Member State that recognises the measure. The recognition and, where applicable, the enforcement of protection measures taken in a Member State should be based on the principle of mutual trust, and the grounds of non-recognition should be kept to a minimum required. In accordance with this principle, only one ground for refusal is proposed. The Member State of recognition may, on an application by the person causing the risk, refuse the recognition of the protection measure taken by the Member State of origin. The abolition of any intermediate formalities for the recognition and, where applicable, the enforcement in the second Member State of a protection measure taken in the first Member State must be accompanied by fundamental rights safeguards. Article 10 of the regulation provides a solid safeguard, since the certificate cannot be issued when the right to a fair trial of the person causing the risk have not been guaranteed. There is also an additional protection for a person causing the risk in Article 12.2, which is the ability to apply for suspension or withdrawal of recognition where the protection measure itself has been withdrawn or suspended. There are duties set out in Article 13 to give notice of the order to both the person causing the risk and the protected person. In addition, under Article 16, an applicant who has benefited from legal aid in the Member State of origin should also be able to benefit from the most favourable legal aid or the most extensive exemption from costs in any proceedings relating to enforceability in the Member State of enforcement. The objective of this proposal cannot be sufficiently achieved by Member States alone because of the transnational aspect of the issue. Only legislation at European level can create a level playing field. The proposal therefore complies with the subsidiarity principle. The proposal also complies with the proportionality principle in that it does not go beyond the minimum required in order to achieve that stated objective at European level and what is necessary for that purpose. The proposal approaches the need for speed, ease and simplicity for the user by enabling certificates to be issued to mirror domestic protection measures, which can be recognised without special procedures and with only limited grounds available for the member state of recognition to decline recognition. It contains no jurisdictional restriction on the issuance of the order and includes ex parte orders. On the other hand, it explicitly excludes any matter which should be dealt with under Brussels 2A from the scope of this regulation, and includes a ground for non-recognition where there is an irreconcilable order between the same parties in place in the member state of recognition. It also provides a regime for the notification of the aggressor and routes to appeal. Enforcement for breach is left to national law. The measure now goes for trilogue with the European Parliament. In conclusion, the Stockholm Programme and the Commission's action plan to implement it recognises the need for further action to place the needs of the victims of crime at the centre of our justice systems. The programme places victims high on the EU agenda and firmly establishes the need and intention to create an integrated and coordinated approach to victims.